To this indictment, the defendant has entered a plea of not guilty, and this makes the issue which you have been empaneled and sworn to try. I caution you that the fact that this defendant has been accused is no evidence of his guilt. You should not consider the indictment as evidence or implication of guilt, and neither is the plea of not guilty to be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence which is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of these factors. After giving consideration to all the facts and circumstances in this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. The law provides that criminal actions shall be tried in the county in which the alleged crime was committed. Venue, that is, that the crime was committed in Athens, Clark County, is a jurisdictional fact that must be proven by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue may be proven by direct or circumstantial evidence or both. It is my duty and responsibility to ascertain the law that applies to the case and to instruct you on the law by which you are bound. It is your responsibility to ascertain the facts of the case from all of the evidence presented. It then becomes your duty and responsibility to apply the law that I give you in this charge to the facts as you find the facts of this case to be. The defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent. But you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any facts which are put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial and stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the indictment, the plea of not guilty, opening or the closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into a stipulation that has been approved by the court about State's Exhibit 113, a photograph of defendant as he existed on February 8, 2001. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence, from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on direct evidence, circumstantial evidence, or both, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence, nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Burglary to a dwelling, aggravated sodomy, rape, and aggravated assault are felonies, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of burglary to a dwelling, aggravated sodomy, rape, or aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For burglary in the first degree, the state must prove that the defendant, 1, entered into and remained in the dwelling of someone else, 2, without authority, and 3, with intent to commit a felony. Aggravated sodomy and rape are felonies, which I will define for you shortly. A dwelling includes a house or any building or structure that is designed or intended to be used as a residence. A dwelling also includes any part of that house, building, or structure. It doesn't matter if the dwelling was occupied, unoccupied, or vacant when the alleged burglary happened, but you may consider these factors in deciding if the dwelling was meant to be used as a residence. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This, quote, breaking of the plane, end quote, must be done by the defendant. The state does not have to show there was an actual break-in to prove burglary. For rape, the state must prove that the defendant, 1, had carnal knowledge, 2, of a female, 3, forcibly, and 4, against her will. Carnal knowledge means sexual intercourse, which is any penetration, no matter how slight, of the female sex organ by the defendant's male sex organ. Force means acts of physical force, threats of harm, or intimidation. Against her will means without her consent. For aggravated sodomy as charged in count 7 of this indictment, the state must prove that the defendant, 1, forcibly, and 2, against the will of a person, 3, engaged in a sexual act, 4, involving the sex organs of one of them, and 5, the mouth of the other. Force means acts of physical force, threats of harm, or intimidation. Against the will means without the alleged victim's consent. For aggravated sodomy as charged in count 10 of the indictment, the state must prove that the defendant, 1, forcibly, and 2, against the will of a person, 3, engaged in a sexual act, 4, involving the sex organs of one of them, and 5, the anus of the other. Force means acts of physical force, threats of harm, or intimidation. Against the will means without the alleged victim's consent. The state must prove that the alleged victim did not consent to the aggravated sodomy. If you find that the victim submitted to this alleged act only because of fear or intimidation, or because of force the defendant used, then you may find that the act occurred without the victim's consent. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A knife is a deadly weapon. A person commits the offense of arson in the first degree when, by means of fire, he knowingly damages any dwelling house of another without his or her consent. The burden rests upon the state to prove beyond a reasonable doubt that 1, the building described in the indictment was damaged by fire, 2, the burning was caused by a criminal act, and 3, the accused was the person doing the burning. The law presumes every fire to be accidental or naturally caused until the state shall prove beyond a reasonable doubt that such fire was the result of a criminal act. A criminal act will not be presumed, and the burden is upon the state to overcome the presumption that the fire was accidentally or naturally caused by proof of the criminal act beyond a reasonable doubt. For possession of a knife during the commission of a felony, the state must prove that the defendant, 1, had a knife, 2, with a blade at least 3 inches long, 3, on his person, 4, while committing malice murder, which is a felony, which is a crime against another person. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. To be voluntary, a state must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had a right to remain silent. 2, if the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for him/her to represent him before any questioning and to be present with him during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offenses of malice murder, felony murder, felony murder, felony murder, felony murder, burglary, aggravated sodomy, rape, aggravated assault, aggravated sodomy, arson in the first degree, and possession of a knife during the commission of a felony. Under Georgia law, prosecution for the offenses of burglary, aggravated sodomy, rape, aggravated assault, aggravated sodomy, arson in the first degree, and possession of a knife must begin within 4 years after the offense has been committed. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown. The burden is on the state to prove that the offense occurred within the statute of limitations or occurred within an exception beyond a reasonable doubt. Now, ladies and gentlemen, as to each of the 12 counts of this indictment, after considering the testimony and evidence presented to you, together with the charge of the court, if you find and believe beyond a reasonable doubt that the defendant in Athens, Clark County, Georgia, did on the date alleged commit any or all of the offenses alleged in this indictment, then you would be authorized to find the defendant guilty on each count. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty on that count. As to each of the 12 counts of this indictment, if you do not believe the defendant is guilty of any or all of the offenses charged, or if you have any reasonable doubt as to the defendant's guilt on that count, then it would be your duty to acquit the defendant as to that count, in which event the form of your verdict would be, we, the jury, find the defendant not guilty on that count. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. By no ruling or comment which the court has made during the progress of the trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of this defendant. Whatever your verdict is, it has to be unanimous, that is, agreed to by all 12 jurors. It must be signed by one of your members as foreperson, dated and returned to be read out loud in open court. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. So, ladies and gentlemen, in one moment you may retire. You may now retire to the jury chambers. Go ahead and elect a foreperson. You may take your notes with you, but please do not begin your deliberations until you have received the copy of the indictment, the verdict form, and the evidence in this case. So if you'll go ahead and gather in the jury chambers, elect a foreperson, and we will give you all the evidence in one moment. And as for the alternates, if you will gather your belongings and meet the court at the front of the bench for further instruction. Mr. Bailiff, you may take the jury to the jury room. Thank you.